Na gavana wa Meru Kawira Mwangaza ameuma nje. Mahakama ya Milimani imekubaliana na Seneti kuwa Kawira alitimuliwa kupitia sheria zilizowekwa. Hebu tusikilize kilichojiri muda mchache uliopita mahakamani.
Gubernatorial impeachment is an invaluable safeguard against impunity and abuse of office that must be jealously protected. It must not be allowed to become an avenue for fighting political proxy wars or resurrecting the ballot box contestations that were determined by the electorate when it chose a particular candidate to hold the office of governor. In that regard, the Senate, as a national legislative body that is able to rise above the din of the county-level gladiatorial arena, is uniquely placed to safeguard the sanctity, probity, and vitality of this very important accountability measure. Watering down impeachment, lowering its bar too low, or allowing it to become a facade that masks hidden political interests runs the risk of Kenyans losing confidence in the process. Interventions by the courts come further down the impeachment path, and thus it is the duty of the primary duty bearers, the concerned county assembly and thereafter the Senate, to ensure that impeachment remains as constitutionally envisaged. Turning back to the present case, and in light of the foregoing, the inescapable conclusion is that the amended petition dated 23rd December 2024 has not met the required legal threshold for success. As outlined above, certain aspects of what was laid before this court and submitted on extensively by the parties has been reserved for determination in another fora, a situation occasioned by the petitioner's choice to split her grievances into two petitions pending before two different high court stations. What this court could safely determine without falling into sub judice was insufficiently articulated for finding in favor of the petitioner. While ordinarily courts would follow the event, in the circumstances of this matter, I am satisfied that it is fit, just, and proper that each party bears its own costs. Disposition and final orders. Consequently, and for the following reasons, this court finds and determines that A. The amended petition dated 23rd December 2024, which is the subject of the proceedings herein, is found to be without merit and is dismissed accordingly. B. The Gazette Notice number 10351, volume CXXV1, number 130, dated 20th August, published on 21st August 2024, and issued by the respondent communicating the decision and/or resolution of the Senate to remove the petitioner from office as the governor of Meru County by way of impeachment is affirmed for the purposes of these proceedings. C. Consequent to A and B above, the subsequent constitutional and statutory actions are free to take place as per the applicable timelines. And D. Each party shall bear their own costs.